Good morning. Sorry that it's taken me so long to get videos posted. Here is the first video from Chapter 2. We're going to talk about the duty to accept patients. I'm going to try to do them in a little bit smaller size so they hopefully will be easier to view through Angel. So, let's go ahead and get started. In Chapter 1, we discussed an introduction to healthcare law. Now we're going to start looking at the treatment relationship between the patient and the provider. Okay? We're going to look at the issue of a duty to treat first. You guys have submitted your assigned case briefs based on the readings, and my video assumes that you've read the cases and have either read, watched, or listened to your peers' case brief submission. So I will not spend a lot of time on the facts of each case. Okay? For the most part, patient-provider relationships are governed by contract law, tort, and fiduciary law. That's really why a lot of people, and I mentioned this in Chapter 1, say there's really no such thing as healthcare law, and that it's really just a compilation of several other areas of law. The treatment relationship starts and ends with contract law, but the time in between is covered by other areas of law. In most instances, the patient-provider relationship is a consensual one, where both parties have to agree to enter into this relationship. So a physician can refuse to accept patients for any reason or no reason. And the same is true for hospitals to a certain extent. However, there are some limitations. Hospitals may not turn patients away in emergency situations unless they have stabilized the patient's conditions. And also, and we'll talk more about this in the next video, but doctors and hospitals may not refuse patients for discriminatory reasons, such as race, sex, or HIV status. And once treatment is begun, it cannot be terminated until the proper arrangements have been made. So, is there a duty to accept patients? Well, the first case that we look at is Hurley v. Eddingfield. Here we have a decedent who sent for the doctor, who's the defendant, appellee. The defendant refused to go treat the decedent, and she died. He gave no reason for the refusal. He had previously cared for the decedent, and we later found out in the notes to this chapter that this was a childbirth case. She was in childbirth. The trial court sustained the defendant's demurrer, which is the response to the plaintiff's complaint, and the appellate court affirmed. The court says that the act that regulates the practice of medicine provides for a board of examiners, standards of qualification, examinations, license to those found qualified, and penalties for practicing without a license. The act is a preventive, not compulsive measure. So in obtaining the state's license, permission to practice medicine, the state doesn't require, and the licensee does not engage, that he will practice at all or on other terms that he may choose to accept. Okay? So it doesn't matter that this defendant has previously treated this individual. A new treatment relationship is established once the patient recovers from an illness or stops seeking treatment for that particular illness. This is really our first exposure to the issue of ethical, moral duties versus legal duties. And usually it's really disturbing to students to see the difference between those two. Why? Well, we are talking about life and death, and many times we're talking about children in these cases, and it makes it very difficult for the outsider to read these cases and then see that there is a difference between moral and ethical duties. I hope that with these cases you are able to look at it from both perspectives, both the patient and the provider, because you can't have a good grasp of healthcare law if you can't look at both. Okay? Not automatically assume that the provider is in the wrong. So, our next case, Wilmington General Hospital versus Manlove, and it's even more disturbing. We have this infant, 4 months old, develops diarrhea. The next day the parents call the physician to confirm that they're caring for the child correctly. Doctor says you are. Later that evening the child starts running a fever. They call the doctor again, who prescribes some medication. The next day he is no better, so they go to the doctor's office. They see another doctor in the practice who prescribes some additional medicine and a liquid diet. The next morning the child's temperature is still high, and the parents know that it's a Wednesday and that the doctor's office is closed, so they go to the defendant hospital's ER. The parents tell the nurse in the ER what's been going on with the child, and the nurse says that the hospital cannot treat him because he's already under a doctor's care and he's got a treatment plan, and if they treat them it might go against the doctor's plan. So the nurse tries to reach the doctor, but she's unsuccessful. She tells the parents to make an appointment with the doctor for tomorrow. The parents go home, they call the doctor, they make an appointment for 8 p.m. that night, but the child passes away after 3 p.m., or a little after 3 p.m. of bronchial pneumonia. So the parents sue the hospital, and the hospital makes a motion for summary judgment. Trial court denies the motion, and they find that the hospital is a quasi-public hospital, although both parties admit that it is a private hospital. But the trial court says it is quasi-public because they accept money from grants, public money from grants, and so the court says that liability could be imposed in emergency situations. The appellate court disagrees with this quasi-public argument. They say it's a private hospital. Private hospital doesn't owe a duty to the public to accept a patient that it does not desire. But the court questions whether the rule applies in emergency situations, especially if that hospital staffs an emergency room. So the court says that you can't deny one in an unmistakable emergency. So then the question becomes, was this an unmistakable emergency? the appellate court sends it back to the trial court for further proceedings with this warning that there must be evidence presented of some incompetency of the nurse, some breach of duty, or some negligence. Liability on the part of the hospital may be predicated on the refusal of service to a patient in the case of an unmistakable emergency. If the patient has relied upon the well-established custom of the hospital to render aid in such a case. Keep in mind, though, that, and we don't know what the outcome is when it goes back to the trial court, but keep in mind that hindsight's 20/20. You know, the particular, especially if you have children, you know how they can spike a fever and seem okay, and you know it's not always apparent that you're in an emergency situation. So it's, like I said, hindsight's 20/20. You know, it may be easy to now look back and see that it was an emergency situation, but in that moment in time, it may not be apparent to the nurse that it's an emergency situation. So the next case is a Georgia case, Weidman v. Shallowford Community Hospital, and it stands for the principle that there is no general right to medical care or to treatment to be provided by the state. Okay, here we have a woman who was 4 months pregnant. She began having abdominal pain. She calls her doctor, who tells her that he'll meet her at Piedmont Hospital. She calls DeKalb County's 911 service saying that she wants to be transported to Piedmont. When the ambulance arrives, she reiterates to the EMTs that she wants to go to Piedmont, but they refuse, and they took her to Shallowford Community Hospital. After some substantial delay there, the attending physician speaks with the patient's physician at Piedmont and she's finally transported to Piedmont. However, her physician can't stop the labor, and she delivers a premature baby that dies within 4 hours. Once again, terrible, awful, horrible facts. The proper resolution of this case requires the court to determine whether or not the Constitution grants a right to medical care and treatment in these circumstances. And does a county's government, we're speaking about the EMT service, alleged practice of using its emergency medical vehicles only to transport patients to certain county hospitals who had a history of paying on time and actually paying the county's medical bills? Does that violate a right that's protected by the Constitution? The court says no. The court says, does the Constitution grant a right to medical care under the 14th Amendment Due Process Clause? No. There is no constitutional duty to provide police, fire, or any other public safety services. So we can't hold those municipalities liable for providing limited services. Her condition cannot be attributed to the county. So what do we know from these cases? Physicians have no common law duty to treat. Hospitals have a common law duty to treat in emergency situations, regardless of payment, but only in severe emergencies. Hospitals have no enforceable duty to treat non-emergency patients. Okay? So what we've learned so far, how do you explain that hospitals have a duty to provide emergency care to all who seek it while physicians are not under such an obligation? Well, this sets the stage for some federal legislation that's entitled EMTALA, E-M-T-A-L-A. It stands for the Emergency Medical Treatment and Active Labor Act. It was passed in 1986, and it was an attempt to prevent what's known as patient dumping. Okay? EMTALA provides that hospitals have to provide the appropriate medical screening to determine whether or not a patient has an emergency medical condition, or to determine if the patient is in active labor. If it is determined that this is the case, the facility must stabilize the patient. Okay? I'm going to talk a lot about EMTALA. Burdett, the U.S. Department of Health and Human Services, is the next case. It's the first case to actually fine a doctor for violating EMTALA's requirements. Okay, Dr. Burdett was fined $20,000, and he appeals that fine that was assessed by the Department of Health and Human Services. So what are the facts of this case? And once again, these are horrible facts for us to deal with. Thankfully, the outcome was good, but a woman presents at the hospital in labor to deliver her sixth baby. She presents at or near term, but has had no prenatal care. She hasn't gone to the doctor at all, and she presents with dangerously high blood pressure. Okay, so she's what this particular hospital calls an unaligned patient. She doesn't have a physician who is caring for her. So the defendant physician was on call for all unaligned patients. Okay, he refused to treat the patient. They call him on the phone, they tell him what's going on. He says that he refuses to treat her because she's not had care, prenatal care, and that he says that she should be prepared to transfer to another hospital that's almost 200 miles away. The nurses and the hospital administrator meet, and the administrator calls Burdett and says that based on the hospital's own regulations and federal law, EMTALA, that the doctor must examine the patient and personally arrange for the transfer. Okay, so the doctor says he'll come in. The nurse asks, can she start an IV of it's a magnesium blend as a precaution against convulsive seizures. Burdett says that the IV can be started only if the patient can be transported. So Burdett arrives to examine the patient, confirms the high blood pressure, the actual blood pressures in the facts of the case, and he makes arrangements to have her transferred. The hospital administrator, takes the EMTALA regulations, tries to show them to Burdett, but he refuses to read them, and he says that this patient is more of a malpractice risk than he's willing to take. The administrator tells Burdett that the patient can't be transferred unless he signs a physician's certificate authorizing transfer. And Burdett signs, he says, give me the paper. He signs the paper They had a space to explain the situation. He doesn't fill anything out, and he just signs it. And he tells the administrator that until the hospital pays his malpractice insurance, that he is going to pick and choose his patients. So then he goes on to care for and deliver another unaligned patient. He never re-examines the first patient again. He never checks on her medical status. He only asks several times about the status of her transfer. So 2 hours after he examined her, she is sent by ambulance with an off-duty OB nurse to the other hospital. Burdett doesn't order any medication for her or any life-saving equipment for the ambulance. About 40 miles into the trip, the OB nurse delivers the baby. The baby is healthy. She directs the ambulance to stop at a nearby hospital to get some Pitocin to stop the patient's bleeding. At that hospital, she calls Burdett, who is furious with her, tells her to proceed to the original transfer hospital. She refuses. They return to Burdett's hospital, where he orders that the patient be discharged if she's stable. Okay, he finally relents to letting another physician on staff care for her. Okay, afterwards, Burdett is fined under the EMTALA legislation. Okay, he appeals under a couple of different arguments. He admits that the patient presents an emergency medical condition, which is the language that's in EMTALA. You can check the EMTALA language in the case. But he argues that the magnesium blend IV was used to stabilize her blood pressure, and so she was stabilized. The court disagrees and says that Burdett did not stabilize the patient prior to transfer. But they said this is not to say that a transfer could never have happened. He just had to stabilize her. They say that it is possible, even in emergency situations, to transfer the patient if the patient requests the transfer, or the physician believes that the benefits of transfer outweigh the risk to the patient. The receiving hospital must agree to the transfer, and it must have the appropriate personnel, life-saving equipment, and transportation to get the patient transported. The physician defendant also argues that subjecting him to EMTALA is basically a taking of his property, which is a stretch of an argument. The court ruled that governmental regulation that affects a group's property interest does not constitute a taking of property, where the regulated group is not required to participate in the regulated industry. Okay, so let's talk a little bit more about EMTALA. EMTALA creates two distinct duties. One is a duty to screen patients that is triggered upon their arrival at the hospital, and it ceases if it is determined that they are not in what the statute defines as an emergency condition. If they are in an emergency condition, then the hospital must stabilize them. EMTALA was supposedly passed to prevent patient dumping, but in the majority of cases it didn't accomplish this. It only results in a delay of a transfer until the stabilization occurs. So it didn't stop facilities from dumping patients. It just stabilized them and then moved them on. Okay? What is dumping? Dumping would be where a facility makes the decision because of, could be a multitude of reasons, but most of the time it's because the patient is indigent and will not be able to pay his bills. They will pass that patient off to another facility. Okay, in most situations, from a private facility to a public facility. In this stabilization requirement, EMTALA doesn't require the impossible to be done. If the hospital doesn't have the personnel or the facilities, the equipment to fully stabilize the patient has to be transferred, it says, to a more sophisticated hospital, and there's no EMTALA violation. While EMTALA was motivated by the dumping of indigent patients, there's no language in the statute that addresses indigents or no insurance coverage patients. In fact, the court has said EMTALA applies to all patients. The most controversial extension of the EMTALA statute came with a case called the Baby K case. It's In Re Baby K. This case involved an anaphylactic child. Actually, this is a child that's born with part of its skull missing, a hole in the skull, and they usually don't live very long. This child was born, and the parents had brought it to the ER on multiple occasions in extreme respiratory distress. Okay, so after this had happened several times, the hospital goes to court and seeks a court order that would allow them to deny all but supportive care for the child. Okay, meaning food, nutrition, hydration, and comfort. Because the hospital argues that treating the child is futile because there's no hope for improvement. In this particular case, the court rules that EMTALA does apply, and that the child presenting in respiratory distress, the distress is the emergency condition. It's not the underlying anencephaly, and that the defendant is required to stabilize the child. EMTALA has not eliminated patient dumping. Hospitals still try to evade the EMTALA obligation and dump a patient before he reaches or she reaches the ER, sometimes by telling the ambulance that the ER is on drive-by status, which means it's full, can't take anymore, and that ambulance needs to proceed to another hospital. EMTALA was then amended and interpreted by the courts to help stop this preventive dumping by saying that once a patient reaches any part of the hospital's property, then EMTALA applies, and the hospital's ambulance is hospital property. Okay, so once they're in the ambulance, EMTALA goes into effect. Now, EMTALA does not allow for it doesn't give you a claim for medical malpractice. So it's a separate issue from medical malpractice. So we'll stop this video right here, and we'll pick up with wrongful reasons to reject patients next.